So in this video I want to introduce the topic of the concept of the separation of powers. Now this is another fundamental constitutional concept that we need to explore before we start looking at the individual institutions of government, things like the parliament, the executive, the judiciary and the royal prerogative. So we're going to take the next 5 or so lessons to really go into a lot of detail and explore the concepts of the separation of powers and explore some of the questions that are relating to this concept as well. So, as an introduction, the concept of the separation of powers generally has 3 subconcepts, okay? So it generally has three kinds of component parts to talk about. The first is the general principle that the same person must not form part of more than one organ of government. So the same one person must not be a part of more than one organ of government. I'm going to talk about the organs of government in a minute. Secondly, the second point is that one organ of government should not hold functions of another organ. So of another organ. And that could effectively be classed as should not hold power. So if you have power in one specific type of government, that institution shouldn't also have the power to do something that would be classed as another function of government. Thirdly, each organ of government must check the others. So that this implies a system of what we call checks and balances. Checks and balances. So not only do they have to be distinct organs of government that have separate people in each separate organ, not only must these organs of government not share power effectively with each other, but to ensure that they are completely separate, they must also check the other powers of the other organs of government. And this is the traditional understanding of the separation of powers. And we're going to find out in the next few lessons to what extent the United Kingdom's constitution and the sort of constitutional regime that we exist under in the United Kingdom, to what extent this kind of separation of powers, this kind of concept, really applies here. Because there are arguments, on each side, of course, there always is. So the general historical basis for this dates back to some of the earliest liberal thinkers. So what can be described as one of the key founders of liberalism, John Locke. So we're going to a founder of liberalism. So John Locke, in his second treatise of civil government in 1690, sort of was the first to really codify this kind of concept of different parts of government being separated and these powers to be separated across these different branches of government. Okay, Montesquieu as well, also in 1748, had his own interpretation, and we're going to talk a little bit about the historical interpretation as well. But it's important to note that the historical interpretation, while it is important, it's more important to talk about the different ways in which this operates in a modern setting, especially within the United Kingdom. So if we accept this idea, this traditional idea of separation of powers, if we accept that this is something that is desirable, that we ought to do this normatively, the question then arises, what should government be separated into? So not only what is government separated into, but what should? So what is the most desirable separation of powers that we can have? And according to the traditional view, again, something that we're going to expand upon in a later video, and something we're going to challenge in a later video as well, according to the traditional view, government can be separated into a three-part structure. We can have a legislature, a legislative branch of government, the legislature being responsible for the drafting, the making and the publication of new laws, of new legislation. You can have an executive or administrative branch of government, and this executive branch functions as the enforcement of the law. Okay, and this can be done through things like the formation of policy and discretionary decision making and action, things like that. Okay, And then finally, you have a judicial branch of government, and the judiciary is responsible for the interpretation and application of the laws that are passed by the legislature. Now, that is the general principle of the separation of powers, and you can probably describe it as being almost like a triangle. So you have an executive branch, you have a legislative branch, and you have a judicial branch, and these three branches are separated amongst each other. And if we go back to the start of this video and we talked about the three concepts of the separation of powers, we understand that no one person can hold power in more than one branch. So if you are part of the legislature, then you can only be part of the legislature unless you want to, say, resign and move into the executive or the judicial. That's the first concept. The second concept relates to the power of the institutions themselves. You can't have a legislature, okay, that has the power to make judicial decisions. That is something that shouldn't be allowed. So the kind of decisions of interpretation cannot be done by the legislature, and the kind of creation or formation of statute legislation cannot be done by the judiciary. That's the second kind of principle. The third principle refers to the kind of checks and balances that can be administered across these branches of government. So the legislature can check the powers of the judiciary can check the powers of the executive, and vice versa, and also across this branch here as well. This is the concept of a separation of powers and the concept of checks and balances. Now, it's very apt to draw the distinction here with the concept of the separation of powers to then look at how this concept is applied in different settings. And the best example to look at probably is the example of the United States again. So in the United States, you have an executive branch, which is concentrated at the White House with a president and his cabinet and the executive office, etc., etc. You have the legislative branch, which is concentrated in Congress, okay, which is divided into the House and the Senate. And at the federal level, at least, you have a judicial branch, which is separated into things like circuit courts, the Court of Appeals, and of course the Supreme Court. And just like when it comes to the principles of the separation of powers, these have separate powers when it comes to government. They all do different things, okay? Somebody who works in the legislative, someone who maybe is a senator, cannot run for president, okay, and then act as president, be inaugurated as president whilst also being a senator. That isn't allowed. And they have checks and balances between each other. You've got things like the power of the president to veto legislation on this branch here going this way, okay? You've got the legislative, the congressional power of Congress to override the veto. You've got the judicial check on the legislature of judicial review, something we'll talk about in English law. And of course, you've got the president being able to appoint Supreme Court and High Court justices and judges. So, of course, this is a very rudimentary example. There are a lot more checks and balances that are found in the US Constitution, but this is a very good. It's very good to get your head around the concept of separation of powers. If it's something that you struggle with, to look across the pond at the United States example, okay, before we start to look at the complexity of the UK's example. This is the last I'm going to talk about the United States, because this is UK constitutional and administrative law, not United States constitutional and administrative law. And then from now on, we're going to talk about UK law specifically.